Good morning, everyone, and welcome to our webinar on recent developments in freedom of information. My name is Catherine Allen, and I'm the head of the Public Regulatory and Investigations team here in Mason, Hayes Curran. And our team is a leading advisor on all aspects of public sector information law, from freedom of information, access to information on the environment, data protection, to confidentiality and privilege. We advise lots of FOI bodies on all aspects of FOI law, including grounds for non-disclosure. And we also advise private sector bodies in interacting with FOI bodies and providing information to FOI bodies. So in that light, I'm joined this morning by two of my PRI partners, Niall, Michel and Lisa Joyce, and more on them in a moment. But just to say, each of their presentations will last around 20 minutes. And we will have some time for Q&A at the end, as you can see from the screen. So what would be great is, as the session proceeds, if you could pop your questions into the chat or the Q&A function, and we will have some time for them at the end. And so turning then to our speakers, Niall is, of course, an acknowledged expert on freedom of information and also in evidence management and disclosure. And for many years, he has consistently advised FOI bodies and those interacting with them on all facets of FOI law and practice, as well as statutory reviews and court appeals. And in other information law matters, he regularly demystifies for clients the technical issues in evidence gathering and evaluation, confidentiality, privacy, and privilege. And Lisa also has a particular focus on information law, and she advises extensively on all aspects of access to and disclosure of information, including FOI, access to information and data protection. And she's also a contributor, a very large contributor to our Freedom of Information sourcebook. And just to keep you on your toes, I know that Lisa has some poll questions in her presentation this morning, so you might watch out for those and respond to them when they appear. So look, that's all from me for now, and I'd like to hand you over to our first speaker, Lisa. Thanks, Lisa.
Thanks, Catherine, and good morning, everyone. So I'm going to look at three topics this morning. Firstly, I'm going to look at some interesting updates from the 2020 annual report of the Information Commissioner, or the OIC, as I might refer to them throughout this morning. That report was published in July 2021. Secondly, I'm going to look at some very recent decisions of the OIC, i.e. within the last 2 weeks. So I hope that they will be both interesting generally and also of general application to all FOI bodies, so to the audience this morning. And then thirdly and lastly, I'm going to look at some planned changes that are coming down the tracks in FOI. So just before we get started, as Catherine mentioned, we have a couple of poll questions. So I might ask that we put up the first one now. And I think you have to vote to see the results. So that's the carrot if you want to see the results of this poll. So the first question is, do you think FOI needs to change? And it's just one choice, yes or no. So we'll see the results of that hopefully shortly. So moving on then to the next slide. So we're going to look firstly at some key statistics from the OIC's annual report 2020. So firstly, and we can see the results of that poll very, very soon. So do you think FOI needs to change? Yes, a whopping 83% of the people that have voted, and no 17%. So quite a small majority of the audience this morning are happy with FOI as it exists. And I think that might become a theme, and certainly something I'll try to address at the end if we have time. So moving then to the key statistics, or some of the more interesting statistics from the 2020 annual report. Firstly, the number of FOI requests in 2020. They've actually reduced. It's 31,500. It's slightly down from the 2019 figure. That's the first time there's been a decrease since 2011. Most likely COVID related though, and I don't think it will continue. In terms of the top 10 bodies who received the most requests, there's no surprise that the top bodies receiving the numbers of FOI requests are the HSE, the Department of Social Protection, and TUSLA. Again, no surprises with the sectoral breakdown of FOI requests. The government departments and state bodies receive the most, followed closely by the HSE. In terms of the categories of requesters, the people making the FOI requests to the public bodies, again, no surprises. The Journalists make up a whopping 23% of all requests. But also, I think, interestingly, 3% of quite a large figure, 31,500, are staff of public bodies. So you can see that staff are also utilising FOI to gain information from their employers. Moving on then to the next slide. In terms of the release rates by public bodies, the numbers of FOI requests granted in full is actually very high at 46%. And I think that might be surprising to some people. Again, it's only the problematic FOI requests that make the media. Moving then to the subject matter of reviews before the Information Commissioner. No surprises that access to records is the highest number of those. But interestingly, at least for me, is the fact that there were 18 appeals relating to Section 10 requests, that's requests for a statement of reasons, and also 13 appeals relating to requests or applications for an amendment of personnel information under Section 9 of the FOI request. They're kind of the two rights under the FOI request that are kind of often forgotten about. Also, interestingly, at least from my perspective, is that there was only one appeal before the Information Commissioner in 2020 that related to an objection by a third party. So that facility or entitlement does not seem to be used by third parties who are affected by the potential release of information. Moving on again, then, we can see that in terms of the outcome of the reviews carried out by the Information Commissioner in 2020, actually 44% of all cases the Information Commissioner actually affirmed the decision of the FOI body. Cumulatively, only 20% of decisions of FOI bodies were varied or annulled by the Information Commissioner. And I think the fact that there's 44% of decisions affirmed shows that for the most part, FOI bodies are actually getting the decisions right when it comes to FOI, and the system is actually working. Moving on then to the age profile of Information Commissioner cases, you can see that 57% of all cases in 2020 were actually closed within 4 months, which is a very short time frame. It's slightly down from 60% in 2019, but again, I think COVID-19 probably played a factor in that. And the Information Commissioner has said in the report that they're actually quite happy with that figure, given the COVID limitations. Moving on then to the next slide, please. Finally, we're going to look at deemed refusals at both stages. So there was actually 139 deemed refusals by FOI bodies at both stages of the process, the first instance decision and internal review stage. That's up from 2019 figure. And again, while the Information Commissioner notes that COVID would have been a factor in this, they are still very concerned about this figure and the increase, and stated that they will be paying particular attention to trends emerging in 2020 on this. So a fair warning in terms of deemed refusals for next year's report. Lastly, then, I think it's always important to remember that the Information Commissioner can issue statutory notices requiring FOI bodies to do certain things. 3 notices were issued in 2020 under Section 23 of the Act. That's where the Information Commissioner is not satisfied with the adequacy of the reasons given by an FOI body for its decision. And in those cases, the notices were issued to Cork City Council, to the then Department of Education and Skills, and to the Defence Forces. And finally, 2 notices were issued under Section 45 of the FOI Act. So under Section 45, the Information Commissioner can require a public body to provide it with information that it possesses or is in its control if the Information Commissioner needs it for the purposes of its review. Those notices were issued to Horse Racing Ireland, who had failed to provide its effective decision to the Information Commissioner on time. Its effective decision is required in the case of a deemed refusal, so the Information Commissioner knows what decision the public body would have made. And the second one was issued to Offaly County Council, who had failed to provide copies of the records to the Information Commissioner on time, despite a number of reminders. And I would just say that I do have some sympathy for Offaly County Council in that regard, because generally speaking, the Information Commissioner will look for copies of the records within 3 days, which is quite a short time frame. So just to conclude on the statistics aspect, while I hope the statistics are generally interesting to anyone that is involved in FOI, they certainly are to me, I do think there is a couple of things to note of practical relevance for people that are working in the FOI field. Firstly, as I said, apart from the COVID blip, I think we can expect the number of FOI requests to continue to increase from this year. That has been the trend for many years now. In fact, since the new Act was introduced in 2014, the number of FOI requests have actually increased overall by 42%, which is huge, and obviously has led from the removal of a charge for making of an FOI request, even though it was quite a small charge. Secondly, there seems to be an increase in the number of applications under Section 10 of the FOI Act for statements of reasons, and this does accord with our experience in advising on FOI requests of late, so I think you should probably expect to receive some Section 10 applications if you haven't done so already. And lastly, the majority of appeals from the Information Commissioner are now completed within 4 months, which is in line with the envisaged timeframe under the FOI Act. So if you are involved in an appeal before the Information Commissioner, I think you can expect that to travel at a very quick pace. Moving on to the next slide, please. I'm going to look now at some very recent decisions of the Information Commissioner. I've selected 6 cases of the last, I think, top 10 cases, and I'm hoping that they will have some general application for you this morning. Again, they were all issued within the last couple of weeks. In fact, I think 4 of them were issued on the same day, and that just supports the point I've just made about the speed at which Information Commissioner reviews are being carried out. The first 2 cases that I'm going to look at actually do relate to Section 10 applications under the FOI Act, which are obviously applications for a statement of reasons of a decision of an FOI body. And again, we are seeing an increase in these. So hopefully it'll be useful to look at these cases. So just by way of a reminder, Section 10 entitles a person affected by an act or omission of an FOI body and who has a material interest in a matter affected by that act to seek a statement of reasons for the act and any findings on any material issues of fact. To have a material interest in the act of an FOI body, the consequence or effect of the act should confer or withhold a benefit from a person. So the first case is Mr. X and the Defence Forces, and it's from the 4th of October 2021. So the requester here sought a statement of reasons under Section 10 of the Act as to why a particular officer had completed their performance review. But they also asked some specific questions around that decision of the review, such as the date that the reviewing officer had made a particular finding and the reasons why there was a delay in receiving the final report. And they'd also sought some copies of records relating to the review. The Defence Forces did provide a statement of reasons addressing the points raised by the applicant and stated that no other records had been produced. However, the applicant felt that this answer was inaccurate and they appealed the matter. For the Information Commissioner, they actually affirmed the decision of the Defence Forces. And interestingly, they found that Section 10 did not require the Defence Forces to provide a statement of reasons for each of the specific acts identified by the applicant relating to the completion of the performance review. If the same outcome would result regardless of the reasons for the act in question, then Section 10 did not apply to each of those acts. So in this case, the applicant was only entitled to a statement of reasons for the substantive decision, not each and every action which was taken in arriving at that decision. The next case then is Mr. X and the Defence Forces, and it's a decision of the 30th of September 2021. So here the applicant submitted an FOI request for certain information. However, the information requested was actually the reason for the decision of a named doctor not to authorize the refund of medical expenses and the legal basis for that decision. The Defence Forces, though, treated this as a regular FOI request for documents and ultimately refused the request under Section 15, subsection 1I, because the requested information had already been released to him during a consultation with the named doctor. The Defence Forces said that it was not expressly clear from the actual letter received that it was a Section 10 application, notwithstanding that it was clear from the wording of the letter that the applicant was explicitly seeking reasons for a specific decision. On this basis, the OIC annulled the decision of the Defence Forces. They said that the Defence Forces couldn't treat the application as invalid just because it did not explicitly refer to Section 10. The Defence Forces should have been aware that the applicant was seeking a statement of reasons, and it should have offered to assist the applicant to prepare a proper request or application under Section 10. Also, they said that the fact that the reasons for the decision were previously explained or discussed with the applicant in a medical consultation did not entitle the Defence Forces to rely upon Section 15(1)(I). However, if documents had previously been released to the applicant, which detailed fully the reasons for that decision, it might have been possible to argue that the Defence Forces had already complied with its obligations under Section 10. So that's the two Section 10 decisions I wanted to mention. Moving on then to two decisions relating to Section 15, which are the administrative grounds for refusal under the Act. Firstly, a frequent cause of appeal in FOI is where the requester believes the FOI body holds some records that have not been released to them. In these cases, where an FOI body refuses a request under Section 15(1)(a) because the records don't exist or can't be found, the scope of the Information Commissioner's review is limited to assessing the adequacy of the searches undertaken by an FOI body. So thankfully, for everybody concerned, the Information Commissioner does not come into your office and actually search for the records themselves. The case is Mr. M and the Defence Forces, and it's again from the 30th of September 2021. So here, amazingly, the requester sought all files relating to unknown aerial objects or unknown aerial phenomena for a certain period. They also sought all correspondence files between the Defence Forces and a specific journalist, resulting in the release of UFO files for September 2007. And lastly, all files relating to unknown aerial objects or unknown aerial phenomena prior to May 1947. So it's not often that I get to speak to a case relating to UFOs, so I'm not going to pass up the opportunity. Disappointingly, the Defence Forces refused this request under Section 15(1)(a) of the FOI Act because no records could be found, and the OIC affirmed that decision. So here the Defence Forces had detailed to the Information Commissioner all of the searches that they had carried out, and they had also noted that the Irish Aviation Authority, and not the Defence Forces, was actually the lead agency in Ireland for this matter, as in unidentified aerial objects. However, the Irish Aviation Authority is an exempt agency under the FOI Act, so the Defence Forces could not transfer the FOI request to them for processing. The Information Commissioner noted in its decision that the FOI Act does not require absolute certainty in order to rely on Section 15(1)(a), because situations do arise where records are lost or simply can't be found. Therefore, the Information Commissioner can be satisfied that the test in Section 15(1)(a) is met, even if the requester doesn't believe that no records exist. Moving on then to the second Section 15 case, this deals with how far FOI bodies have to go to assist a requester under Section 15 subsection 4 before they can refuse a request because it is unspecific or burdensome. And this is something that we find in our experience can trip up quite a lot of FOI bodies. So again, hopefully worthwhile having a look at this morning. So the first case is Ken Fox and the OPW, and this request is dated the 29th of September 2021. So it concerns a request for access to copies of all records held by the OPW referring to or relating to the TV programme Room to Improve, Dermot Bannon's show, and this show had featured on RTE primetime on a specific date. The number of records relevant to the request ran into the thousands, and the OPW duly contacted the requester and invited him to narrow the scope of the request. The requester did that and narrowed the scope of the request to refer to emails associated with the OPW and the chairman's email account only, the OPW chairman's email account only. However, the OPW then just went on to refuse the request under Section 15(1)(c) on the basis that it was too voluminous. The OIC then actually annulled the OPW's decision. They said that while the OPW had given the requester one chance to define the scope of his request under Section 15 subsection 4, it had not offered reasonable assistance as required. And they noted that the level of assistance required will vary significantly from case to case, but one factor can depend on the willingness of the parties, in this case the requester, to actually engage in a meaningful discussion on the scope of the request. So here, the requester was willing to engage on refining his request, and he had done so once, but the OPW didn't engage with him any further on that and didn't explain why his suggested amendment was not acceptable, or provide any advice in relation to how he might further refine the request to ensure that it was not burdensome. It simply refused the request under Section 15(1)(c). So I think you need to be prepared to have an ongoing dialogue with FOI requesters in that regard, and there could be maybe a series of engagements to correctly refine the scope so that you can process it. Moving on then to a decision that relates to Section 37 and the exemption for personal information, and in particular the release of details related to the staff of and contractors to FOI bodies. The legal position on this has been clear for some time, and it's been the same since the introduction of the Act in 1998. However, particularly in the era of data privacy and GDPR, it's understandable that there can still be reluctance to release specific references to staff in certain documents. So this case is again relates to Ken Fox and the OPW, and it's a case dated the 30th of September, so just the day after the last one. Again, the OIC is cracking out the decisions at this stage. So the request concerned, the request was for copies of any contract documents and certain payment records between the OPW and the Merrion Square co-ownership group with regard to the purchase of some properties in Dublin 2. The OPW part granted the request but refused access to third-party personal data under Section 37. The OIC then varied the decision of the OPW. It found that they were correct to redact under Section 37 the identities of the property owners and their solicitors, an individual who was a partner of the co-ownership group, and individual directors of other partners of the co-ownership group. However, the OPW was not correct to redact the identities of current and former civil servants. That information is clearly excluded from the definition of personal information under the FOI Act, and so can't be exempt under Section 37. The Information Commissioner also dealt with the interplay between FOI and data protection, which is worth bearing in mind. Basically, the FOI Act is entirely independent of data protection legislation, and the data protection legislation does not override the exclusions from the definition of personal information under the FOI Act when you are dealing with an FOI request. And lastly, the Information Commissioner also clarified that the exclusion from the definition of personal information does apply to service providers to an FOI body, but only where the service provider is an identifiable individual. It doesn't apply where the service provider is a legal entity, such as in this case, the Merrion Square co-ownership group. So on that basis, the OPW was correct to exempt personal information comprising the name of an individual partner of the co-ownership group and the names of the directors of other partners to that group. The last case I wanted to mention then relates to Section 29, which relates to the deliberations of FOI bodies. And in my experience, this exemption is frequently applied. So I think, and I think the Information Commissioner has given some helpful guidance on how you can properly apply it. So the case is Mr. X in the Department of Agriculture, Food and the Marine, and it's again a decision of the 30th of September 2021. The requester had sought access to all records concerning shellfish licenses in Valentia Harbour. The department refused the request under Section 29 and under Section 31, legal professional privilege, but we don't need to look at that this morning. So the Information Commissioner actually affirmed the decision of the department. In relation to Section 29, it accepted that the license process was deliberative in nature and that releasing the information at this point could prejudice the department's ability to conclude that process properly. But in addition, the decision also sets out some helpful comments on how to correctly apply the exemption. Firstly, nothing in Section 29 requires the deliberative process to be ongoing, but the question of whether it is or is not ongoing may be relevant to the issue of the public interest. Secondly, the public interest in Section 29 1b differs from the general public interest override because the decision maker has to consider that release is actually against the public interest, not just that the balance of public interest favours refusal. Thirdly, when considering if release would be contrary to the public interest because the requester would become aware of a significant decision that the FOI body proposes to make, the relevant issue is not just whether the decision is significant, but also if release would make the requester aware of the nature of that significant decision. And lastly, and most interestingly, at least from my perspective, the Information Commissioner noted that the exemption does not apply to factual information, and also that Section 18 of the FOI Act allows the redaction of exempt material unless the resulting copy record would be misleading. Here, the Information Commissioner accepted that factual information is often inextricably linked to other types of information, such as proposals, opinions, and so on, that would be covered by Section 29. And so here it wasn't practical to extract any factual information from the records, while at the same time ensuring that the redacted copies of the documents were not actually misleading. Moving on then to the next slide, please. So that's the end of the 6 cases. Apologies for the speed, but it's necessary this morning. I'm just going to pop up the second poll question now. Hopefully everybody is still with me. So the poll question is, what is the biggest challenge for FOI bodies under the Foi Act? Is it dealing with the number of FOI requests, dealing with burdensome requests, or complying with short time limits? I appreciate these aren't the only challenges for dealing with FOI requests, but these are the top three that occurred to me. So if you want to vote for that now and submit your vote, you'll see the responses in a minute. So the final thing I want to just run through is some recent changes that are coming down the tracks in FOI. So firstly, the government in September approved a plan for the review of the Foi Act to look at bringing it up to date. A public consultation on the scope of that review is to commence later this year, and then early in 2022, based on that scoping survey, a full public consultation will be undertaken, as well as some research work. And it's intended that that will be concluded by the middle of 2022, and then a report and recommendations will be presented to the government and published at that time. At that point. The second kind of change coming down the tracks is that there is going to be a new information commissioner. So in around December 2019, I think Peter Tyndall, who is the current commissioner, announced his intention to step down from his role. The minister has asked the Public Appointments Service to undertake an open competition for that post, and the recruitment process is expected to conclude towards the end of this month, after which the minister will make a recommendation to government. And then lastly, there is a private members bill on FOI before the Dáil at the moment. It was introduced by Deputy Mairead Farrell of Sinn Féin following Senator Depone's the Senator is Depone appointment issue, and admissions by the Taoiseach and the Minister for Foreign Affairs that they had both deleted relevant material from their mobile phones. And one of the interesting aspects of that bill is that it proposes to increase accountability by allowing the Information Commissioner to reject an application for a review by that office and instead refer a complaint to the Standards and Public Office for investigation if they think that the FOI body intentionally or recklessly failed to fulfill their obligations in a material respect under the Act. So that's all I want to mention this morning. Nothing left for me to do except to reveal the results of our poll, which is that 53% of you this morning think that the biggest challenge for FOI bodies under the FOI Act is dealing with burdensome requests. 34% think it's complying with the short time limits. That's the one I voted for, just in case anyone is interested. And 12% dealing with the volume or the number of FOI requests received. And I think burdensome requests are probably one of the most challenging things. So I think I will agree with that this morning. And we could discuss those further in our Q&A session. So that's it from me. I'll hand over to Niall. Thank you very much.
Thanks, Lisa, and good morning, everyone. I'm going to be speaking to you today about recent court decisions, and since our last seminar, there have been a number of decisions in the superior courts, but not that many, funnily enough, compared to, for example, in the area of access to information on the environment, which seems to have provided a fertile sort of breeding ground for cases before the courts. But having said that, the court decisions that I will be talking about are significant and of systemic importance to FOI. So I hope to share some insights with you from 4 decisions, 1 from the High Court and 3 from the Supreme Court. Incidentally, the High Court decision I'll be talking about is under appeal to the Court of Appeal, has been heard by the Court of Appeal, but a decision on that is awaited. So the High Court decision is still the one that we're operating under at the moment. And just to give you the context of these decisions, you'll be aware that the FOI Act provides for 3 stages of decision making, 2 of them internal within an FOI body, and then 1 external before the Information Commissioner on review. And it's when the Commissioner's review is then the subject of an appeal by some party, be it the requester or the FOI body concerned, or indeed any other party who's unhappy with the Commissioner's decision as a matter of law, they can appeal to the High Court. So all the decisions we'll be examining today, are decisions of the superior courts in such appeals. Now, as I say, they are quite significant in terms of their importance, and in particular, I suppose they, as always, help us to understand, interpret and apply the FOI Act better. And they, in particular, give us practical guidance on what to do when we're dealing with and deciding on requests, when we're explaining or justifying decisions to refuse access, when we're dealing with reviews before the Commissioner, and we want to have a better understanding of the role functions of the Commissioner and the nature of the review process. And finally, when we're considering whether there are grounds for appeal to the courts from decisions of the Commissioner and what are the scope and limitations of such appeals. So let's crack on then and have a look at the decisions themselves. The first case I'll be looking at is Minister for Health and the Information Commissioner. That's a decision of the Supreme Court. And this case deals with the central issue of when a record is held by an FOI body. And as you know, the right of access applies only to records held by FOI bodies. The decision clarifies when a record in the physical possession of an FOI body is not in fact held by it within the meaning of the Foi Act. So it had previously been thought, and the Commissioner thought in this case, that when it comes to records that are physically held, these are clearly held by the FOI body. And the only further question then is whether any of the grounds for non-disclosure apply so as to prevent them being granted. So what was in issue in this case? Well, here the Minister for Health had appointed a retired High Court judge to conduct a non-statutory ad hoc inquiry relating to the abuse of patients at Our Lady of Lourdes Hospital in Drogheda. The judge had then conducted interviews with relevant persons and had assured them of confidentiality. Transcripts were then prepared, and on conclusion of his work, the judge deposited all of the records of the inquiry in sealed boxes with strict express conditions attached to them in terms of the records not being accessed or disclosed by any person, save on foot of a court order for discovery. The judge was to be notified in the case of anybody seeking to gain access to the records in any way. So effectively, the transcripts and other materials relating to the inquiry were sealed up in boxes and deposited with the Department of Health. Now, a requester sought access to a copy of one of the transcripts and addressed his request to the Department of Health. And the Minister refused access on the basis that he didn't hold the records, properly speaking, even though he physically had them in his possession. Now, eventually the matter came before the Information Commissioner, who found that the record was held by the Minister and that it should be released. However, the Minister appealed to the High Court on the point of law, and eventually the matter came before the Supreme Court. So what do we now know, and what did the court say? Well, the court noted that in the long title to the Act, reference is made to providing a right of access to information in the possession of public bodies. Now, it's information, but as we know, the focus in FOI in this jurisdiction is on records, recorded information, and not information per se, say, for example, that's recorded in somebody's head, but not recorded in any record. But records contain information, and the court held that in order to be held, or in order for a public body or FOI body to hold a record within the meaning of the FOI Act, it must be in lawful possession of the record in connection with or for the purposes of its business or functions. And in addition, it must be entitled in law and or in fact to access the information in the record. So as we saw in this case, there was no right of access to the record. Essentially, I suppose the court came to the sensible conclusion that if you can't even, as it were, open up the record and look at it and have regard to the information in it, you can't be expected to decide on the extent to which it should be released or withheld, and so on. So if, as the court said, if the minister didn't have, and he didn't, any entitlement to gain access to information in the record, given that the right of access exists so as to give access to such information, the record couldn't be considered to be held by the minister within the meaning of the Act. Excuse me. Now, the High Court had said something similar, but one thing the Supreme Court specifically disagreed with was the view of the High Court judge that the record must not be subject to any prior legal prohibition affecting its disclosure. Now, that was not the test. It was more that you be entitled to access the information in the record, not that it be subject to a prior legal prohibition affecting its disclosure. That, the Supreme Court thought, was a matter for applying exemptions rather than considering whether or not the information was, or the record was held at all. So what are the practical implications and the learnings going forward? Well, I suppose this case might be confined to its own particular facts, which were somewhat unusual. It's often the case that records are held lawfully and in possession of FOI bodies for the purpose of their functions, and that they're entitled to access the information in the record. But there may be cases which share materially the same unusual facts as this case, and which in which the case will be of assistance to FOI bodies in terms of deciding that they actually don't hold the records, even though they're in physical possession of them. And an example actually given by Supreme Court would be, for example, if members of staff happen to hold records within the FOI body that relate to purely personal matters. Clearly, they are physically within the possession of the FOI body, but they don't relate to the functions of the body. They're not lawfully possessed by the body for those functions. And arguably, I suppose, if they're personal information, they're not, the FOI body wouldn't be entitled to access the information in the records. So there's a practical example that might come within the scope of this decision. Also, I suppose there may well be other cases where records are merely deposited with or accidentally held by an FOI body, otherwise than in connection with their business or functions, and these can clearly be ruled out as not being held. Finally, I suppose it could help with situations I've come across in practice on a number of occasions where two related bodies come under, well, one of them might come under FOI and one might not, and yet they share storage of records, and an argument is made that the FOIable body is in possession of the records and must therefore entertain, process, and make decisions on release or otherwise of the records that, properly speaking, belong to or relate to the functions of the other body that doesn't come under FOI. And I think this case will help determine such cases a lot more clearly. The second case I'm going to look at now is a case, the one I mentioned, the High Court case relating to, which is under appeal to the Court of Appeal and in which judgment is currently awaited. It has been heard by the Court of Appeal, but we don't know yet what the judgment is. That's Jackson Way Properties and the Information Commissioner. And this case clarifies when an FOI body can justify a refusal on the administrative ground in section 15(1)(c) that basically dealing with the voluminous request would cause a substantial and unreasonable disruption of or interference with its work or the work of in one of its functional areas. As you may know, section 15 of the Act contains these administrative grounds for refusal. They're not sort of exemptions properly so called, but they do allow public bodies and FOI bodies to refuse access requests where basically they would be overly and unduly administratively inconvenient. Here, as we see, it relates to whether or not the request, given its nature and given the nature of the records and given the number of records concerned, whether dealing with that would cause a substantial and unreasonable interference with or disruption of work of the FOI body, and that includes disruption of work in a particular functional area. Now, this case concerned a voluminous request to Dundee Rathdown County Council, and it involved multiple year ranges, 72 hard copy files, over 9,000 emails, 262 hours worth of examination of files and records, and so on and so forth, in circumstances where 6 different departments would have to be involved, numerous staff of the FOI unit and the legal services unit who had other work to do and would be very much compromised in doing that work if they had to deal with this request. It is surprising, incidentally, that Dundee Rathdown did not refuse this request on the basis of the cost of search, retrieval and copying, because it would clearly have been over the overall ceiling limit prescribed for requests at which requests can be refused. So that's just a note, but in any event, it was dealt with on the basis of substantial and unreasonable interference with or disruption of work. The Commissioner agreed actually with the public body that Section 15.1c applied and that its application had been justified, but Jackson Way appealed to the High Court, but the court upheld the Commissioner's decision. So what do we now know, and what did the court say? Well, work is any work of the FOI body that it lawfully carries out within its remit in an intra vires fashion. It had been argued that it was confined to core statutory functions and not, for example, the processing of FOI requests or the doing of legal work, or, for example, processing GDPR data subject access requests and other work. So the court said no, work is to be given its ordinary meaning. It's any work that is lawfully within your remit and includes duties such as dealing with FOI requests. The court noted that the previous version of the FOI Act referred to disruption or interference with the other work of an FOI body, and this was replaced in 2014 with just the word work, and that made it clear that it's any work and not sort of the day job work of the FOI body. It's also notable, the court said, that since 2014, the work that can be disrupted or interfered with is work of a particular functional area of the FOI body. And here we had functional areas, the FOI unit, for example, the legal services unit, and it doesn't have to be disruption of or interference with the overall work of the entire body. The court noted that substantialness and unreasonableness are cumulative criteria, but that the same factors can go to establishing both substantialness and unreasonableness. And these include the things referred to in the section itself, as well as things like the time, the staff resources required to retrieve and examine the records, and the impact on the work of the body or a functional area of the body of the deployment of staff resources in that way. Now, substantialness and unreasonableness are slightly different things, even though the factors that go into them overlap. Substantialness refers to the scale or size of the disruption of the disruption or interference. So it's how big is the disruption interference, but then interference says, well, how unreasonable is it in the circumstances, even though it's big? So unreasonableness can include evaluating the disruption having regard to, for example, the overall size of the body. So if the substantial disruption and interference and the body is quite small, that would be relevant. So it's quite disproportionate to the size of the overall body. It could relate to, how many staff there are that can be deployed, what the impact of the request is on the work of those staff and their ability to do their work generally. What is the impact of the request on the work of the body overall, or what is the impact of the request on one of its functional areas. Court also said that potentially relevant matters to be considered would include those identified in the section itself, being the number and the nature of the records, the nature of the information, the nature of retrieval and examination of the records, and the nature of any interference with or disruption of the work. The type of the work being disrupted, I suppose that might include the importance of the work or the difficulty of the work and the extent of that disruption. One important point that the court noted was that when you're evaluating the unreasonableness of the disruption or interference, you can't consider the necessity or the purpose behind the request or any reasons that the requester gives for the request, including any reasons, I suppose, that you might yourself harbor as to why the request might be made, because Section 13.4 of the Act, as you may know, makes all of these considerations inadmissible in FOI decision-making. So when you're saying to yourself, yes, this is a substantially burdensome request and it would disrupt or interfere with work of the body, you're asking yourself then, is it also unreasonable? You can't take into account for a fact that the requester doesn't have any particular reason or any good purpose behind his request, or you suspect they might be making the request for other reasons and so on. Purpose and reason and underlying suspicions related to a request are irrelevant. The final case that I'm going to look at is Minister for Communications and the Information Commissioner and UCC versus the Information Commissioner. The Minister for Communications case is known as the ENET case. These were heard together and they clarify when exactly a record is exempt. Excuse me, I'm just going to take a glass of water. How to apply and justify exemptions properly, what public interests are to be weighed when considering public interest overrides, and whether and how exemption of a record needs to be justified to the Commissioner in order to avoid a refusal decision being annulled by the Commissioner. The two cases were similar and both involved requests for access to records comprising commercial agreements between the FOI bodies concerned and third parties, and involved claims to exemption under sections 35 and or 36, being the confidentiality and commercial sensitivity exemptions. I suppose to understand how this came before the Supreme Court, you have to understand that the Court of Appeal eventually, and the High Court in these two cases, from which the appeals then went to the Supreme Court, had fastened on section 11.7 of the Foi Act, which says that there's no right of access to an exempt record, so that when a mandatory exemption applies, or an exemption applies when the public interest test has been determined as not favouring release, there's no right of access to the record concerned. And the High Court and Court of Appeal found that when you come before the Commissioner then, you can't be made to justify your decision against a presumption of non-justification under section 22.12 because the Act doesn't apply. There's no right of access to the record. But the Supreme Court disagreed with that, basically turned it on its head and said the focus is not on section 11.7, it's on 22.12. What does it mean by that? Well, yes, of course, there's no right of access to an exempt record, but that doesn't mean that you must properly decide on a fully reasoned and fact-specific basis that an exemption applies. And when it comes to the public interest override, you must also look at the specific contents of the record, weigh up the public interest and whether disclosure of those contents outweighs the upholding of the interest protected by that exemption. And then you have a prima facie exempt record. But if the matter is then appealed to the Commissioner, the Commissioner is statutorily presumed to presume that your decision was unjustified, and you must justify it on a balance of probabilities to the Commissioner's satisfaction. Otherwise, you risk the Commissioner annulling your decision. So there has to be some arbiter as to whether section 11.7 applies and as to whether there is a right of access to the particular record or not. There's a whole lot of useful things said in the judgment. In particular, you can't just assert that an exemption applies. They are to be applied and interpreted restrictively and sparingly. You must give a fully reasoned and sufficiently coherent fact-specific explanation that is logically connected to the record as to why an exemption applies. And I suppose on the other hand, it makes it easier for an FOI body to refuse a request on the basis of the public interest not overbearing the public interest in upholding the exemption, insofar as the Commissioner had erred in law here, according to the Supreme Court, in saying that, you know, when you're looking at a record in the public interest in release, you look at things like the general interests of transparency, openness, accountability, disclosure of public funds being transparent, whereas the court has now made it clear that you're looking for something specific in the record. Would it, for example, disclose things like corruption, bribery, untoward practices, or other things that are specifically in the record that it would be in the public interest to release? You're not looking at whether it is generally a good thing to release records of this type or a good thing to release records under the FOI Act. So I think that I'll leave it at that now because we need to get to our questions and answers. But clearly, if anybody wants to ask questions in relation to those decisions, there's a lot more in them and there's a lot of guidance to be got from them. But I'll leave it now to the Q&A. Thanks.
Thank you very much, Niall, and thank you also, Lisa. Now we have a short time for some Q&A, and we have already some interesting questions in. So let's have a look at what we have. Niall, maybe I could ask you to take the first one, which is, what have the court said about when they will interfere with decisions of the Information Commissioner?
Thanks, Catherine. Well, yeah, the appeal, as I said, is an appeal of point of law only, so the courts have fastened on that. It's not another decision maker in the chain of FOI decision makers making an actual decision on the request. So the courts are only interested in whether there's an error of law on the part of the Commissioner. So it won't interfere with findings of the fact, the courts will not interfere with findings of fact by the Commissioner or any inferences he draws from facts found. So sometimes you'll find primary facts and then he'll infer certain things and then he'll apply the law to those inferences. That's all something that the courts have said they will defer to and that they're required to defer to, because the Commissioner has been put in place as an expert decision maker to make these findings of fact. So even if the courts would disagree, as long as there's some evidence, some material before the Commissioner that bases his finding of fact, they're not going to interfere. Similarly with inferences, if the Commissioner draws one inference, it's not unreasonable, and the court might have drawn another inference, it won't interfere. However, if there isn't any evidence or no material to ground his decision, they will interfere. But in the main, what they will do is they'll interfere where the Commissioner has simply misinterpreted the law and misapplied it to the facts. Just by way of caution as well, they will require that you, if you're before the Commissioner, raise issues of law before the Commissioner in order then to be able to raise them in an appeal to the courts. So if you haven't argued something before the Commissioner, then get the decision from the Commissioner, then appeal it on a point of law to the High Court, said it's wrong because of something I didn't argue before the Commissioner, you'll be told you can't argue it at that stage. So it has to be something you argued before or clearly arises from his decision. By way of comfort to the Commissioner, the court said they won't parse the wording of a decision of the Commissioner as if they were parsing a statute. And they may forgive some kind of shorthand usage or looseness of language in the Commissioner's decision. So I suppose, as I say, that's a comfort to the Commissioner in these appeals.
Great, thank you, Niall. Lisa, if I could ask you to take the question, if you ask the requester to refine a request, is the date of commencement of the processing of the request that date refinement is agreed?
Yeah, so our view is that it is, and that's because of the wording that's in section 15, subsection 4 itself, because it talks about refining the request for resubmission. Also, from a practical perspective, I don't think it would be workable if that wasn't the case, because you could spend, as evidenced from the case that I discussed earlier, you could spend quite some time over and back agreeing a refinement with a requester. And it could be eating into your time. So also, if you were using section 15.4 because it was an imprecise or insufficient particulars in the scope of the request, it wouldn't be a valid request at all. So time might not be running against you. But I think generally speaking, my view is that the answer to that is yes. Once you agree the refinement, the refined request is resubmitted for processing at that point.
Okay, thanks, Lisa. And if you don't mind, we might stay with you for the next question. And I think this could be quite a long answer, but maybe we could keep it short, and it links into your poll question. So what changes do you think should be made to the FOI Act following the review that is underway?
Yeah, so I mean, as I said, like I voted for that question so that I could see the answer, and my answer was around the time limits, because I always think that the time limits under FOI are ridiculously short. It's almost impossible to comply with them sometimes. And again, you're only allowed to extend the time if it is due to the volume of records that are requested, which might not be applicable at all. So I do think that time limits is a problem. So even if they're not going to extend the 4-week time limit for processing a request, they could maybe consider lengthening the extension period that's available. And if you look at it by comparison under GDPR, you can extend, it's a 1-month period, which effectively equates with our 20 working days under FOI, but you're able to extend it for a further 2 months, giving a total 3-month period in certain circumstances. And I think in terms of it ties into one of the biggest challenges under FOI that I see, which is that the amount of records and information that everybody holds is just increasing exponentially at the moment. And so even the process of searching and retrieving records for FOI bodies is getting harder and harder and harder, because there's more places to search. There's electronic searches, there's mobile phones, there's whatever. So by the time you even find the records that you need to consider, quite a lot of your time period can be taken up. And obviously the critical part, or the most important part of processing any FOI request, is to actually review the records and determine if they should be released. So I think that's and I think that made the poll, the response to the poll question was that the biggest challenge was burdensome requests. But again, and as Niall mentioned, in the Jackson Way case, that was a huge volume of requests, but yet there was a reluctance by the FOI body to actually refuse because it was over the cost threshold or whatever. And I think a lot of FOI bodies there is a reluctance to refuse a request on some of the administrative grounds because reputationally it may not look great. They generally want to process FOI requests. So the time limits may be somewhere where we can kind of seek a compromise.
Just on that, if I could chime in there as well, you mentioned the Jackson Way case and the administrative grounds. I do think that whilst it was interesting, the poll results said burdensome and time were issues, right? As you say, a lot of people try and take on the task rather than insisting on, I suppose, the rights, the give and take under FOI. So as I mentioned, it would easily have been the case that the County Council could have said, this is over the overall ceiling limit of €700 worth of search, retrieval and copying. If you don't refine it, and we can help you do that, below that level, we simply don't have to deal with this. And in addition, then, if it was refined to below the €700 worth, charge a deposit, again, failing payment of which nothing has to be done on the request. So there's a lot of things that can be done that aren't being done to make requests more manageable.
Thanks very much, Niall and Lisa. Just taking the next question, and I might take this one myself, just in fairness to Niall and Lisa. So the question is regarding the new private members bill and referring the matter to the Standards and Public Office if they feel that the deletion was not right. Do you think it will become law? Hard to balance your data retention deletion policy before FOI is made in those cases. So first of all, in relation to the precise wording of the private members bill, I don't think it would become law in its current form at any rate. Just the wording of the legislation, the proposed amendment, I think is too imprecise and not something I think that would be likely to get past the AG's office, perhaps, in terms of what should be in primary legislation. But leaving that aside, I suppose that the concept of balancing data retention schedules under the data privacy legislation with FOI, I suppose it is important to remember that the data protection legislation does not actually prescribe any particular period for retention of data, nor does the FOI Act. So it is a matter for FOI bodies and data controllers, which may be the one and the same, of course, to decide on their retention policies and retention schedules, and to decide on the appropriate categories for retention of records. And some of those periods will be set down by statute, some of them will be set down by best practice guidance in particular practice areas. Some retention periods will be determined, for example, by statute of limitations, limitation periods, and then some retention periods will simply be determined by whatever the public body or the FOI takes the view, in the absence of any of the other criteria, is the appropriate retention period for the record concerned. And in general, my experience is once you have a retention schedule and you operate your retention in accordance with that schedule, most regulators, the DPC in particular, is not that interested in the precise content of the schedule, or more that you have one and that you follow it. So I don't know if that helps in response to the question, but that's my view in relation to it. I think we are almost finished the time, so I might just take one very final question if I could. Niall, you might take this one if you wouldn't mind. If there is a specific difference between records that are held or possessed by an FOI body, I think that might link into your Minister for Health case, perhaps.
Yes, exactly. I mean, that's squarely what the Minister for Health case deals with. You can possess a record but not be deemed technically for the purpose of FOI to hold the record. And as the court said in that case, the test is, are you in lawful possession of the record in connection with your business or functions? And secondly, are you entitled to access the information in the record? And is there any impediment in law or in fact to your accessing the information in the record? And if that test or those tests aren't satisfied in a particular case, well, then the record that you are in possession of physically is not held by you under FOI.
Thank you very much, Niall. I can see we have lots of other really interesting questions there, so I'm really sorry that we don't have time for all of them today, but I have to bring the seminar to a close. And thank you again to both of our speakers, Niall and Lisa, for their fantastic presentations. Thank you also to all of you for your participation this morning and your interesting questions. Just to say that a feedback survey will automatically appear on screen once the webinar ends, and we would really appreciate your feedback in relation to the